Ladies and gentlemen, I'm your host, Max, and you know what time it is. It's time to expose another round of Karens. This time, it's not at the grocery store or the parking lot. Nope, we're changing settings today and taking a look at Karens in court. Yup, not even the law can hold them down. So sit back and relax. Let's get started. Karens don't switch off their Karen behavior even if it's the weekend, much less if they're in court. Guess they carry the burden of being the most insufferable people around.
I have no complaints. I started
Just have a good day. Hope the tires didn't get you a lot of money.
No, same thing.
Yeah.
Hey, sir.
Yes.
So here's the thing. My determination right now, everything you're doing is perfectly fine.
It's legal.
Unless somebody tells me otherwise, it's perfectly fine.
It's perfectly legal. I know.
Well, yeah, I have no reason to, like if you come to the police department, you can videotape an
I know. We have.
You can't go in the courtrooms.
We have. I was going to today, but we're all busy here.
No, I understand.
I
So,
was going to go to the one on 1402 Miracle Mile. Then I have to go see Captain Sayer at on Alvernon and 22nd, and then I usually start off at the IA down there on the
I don't
Stone.
have any problem with that.
240 North Stone.
You've never,
South Stone.
you never bothered me before, but I just keep
Yep.
them.
I know that.
Everybody just do and respect the rights of people who don't want to be videotaped.
We got that. I will blur, but we're gonna. But you got to remember, the people that don't want to be videotaped and work for the city, that don't count.
Well, if they're on duty and they're working,
That's right,
then
and that
it's
includes the
just
clerks
videotaped.
behind the windows, the ones in the offices. All of them can be recorded on duty.
I'm not disagreeing with you. I'm not. I'm just saying, just if you don't do anything that makes it a crime, then
Yeah, I know.
yeah, okay.
We're well aware of it.
Anthony's the one I worry about, because he gets wound up.
Yeah, but he got arrested
Not just
17 times, and he won every one. He's 17-0 against the city.
I'm not just.
It's all First Amendment stuff, because the loudness, they always get them for being loud. Well, there's no law in there that says how loud you can be. Now you'd have to get a
pretty vague.
decibel, very vague. So we usually when he's loud, he's talking about the Constitution. So
Trust me, I know.
yes,
And it was me over city court, or city hall, not here. Just so
Yeah.
you make the check mark that I got that one right.
yeah, I saw that. Yeah,
Okay.
I just saw that. I thought it was here because it was the background was so small, and it was with it was within with Dave Diable.
Yeah.
It was with him wearing there.
Okay. We good?
Yeah, Slinky used to work here. You probably noticed that by now. He used to work for the prosecutor's office.
So he sounds like, yeah.
He
I
knows.
recognize him from something.
So he knows the law, and he knows that we
He's
can't.
actually very reasonable to talk to.
Yeah, he's he's the lawyer. I wouldn't call it reasonable.
Yeah, you're right.
I never talked to a reasonable lawyer in my life.
That is a good point.
Him being unreasonable is why we like him.
Now, what's your first name?
My first name is Tucson. Remember, Tucson Police Up? That's my name. And you'll go on there. Everyone, they all know my name. Down in, talk to Captain Sayer or any of them know my name. I go to every C-Park meeting.
Okay. I try not to talk to all those bosses.
And I film that too, that they let me. They actually like it. We post the whole meeting online on my page, Tucson Police Up.
I'm going to go.
Yep. All righty, sir. You have a good day.
Let me get
And Brandon Williams knows who I am too. Talk to Brandon.
What's that?
Brandon Williams. He knows who I am.
I just talked to him on the phone.
Yeah, he knows who I am. So he'll tell you my name. I don't want to say it on here because a lot of people are watching.
No problem. I just makes it easier to me to talk.
Yep.
Excuse me. Sorry.
So that guy in the purpley shirt, I guess he's the head of this place, is what they're telling me. He's the one that was starting to do a survey, you know, do people want to be recorded?
Excuse me, sir. Can you give me a hand here while I get the coats out?
Oh, can we give him a hand? I want to-
Three coats that are stuck in.
Oh man. See if we can give him a hand.
You know what? You know what happened? He got up to the window, and they told him, "We won't help you unless you turn off the thing."
Okay.
So she closed down the window, and she won't help him.
Okay.
And he's sitting there in front of the blind window. I say, let's just leave. I mean, we
Here, here.
can't.
Let's go film that then.
Yeah, you can film him doing that. He's just sitting there. She won't open the window. She won't give him motion.
Which
She
one?
won't do anything. She just closed the window.
Oh. No problem. That's easy solution. Got you covered, Anthony. Ma'am, he needs help. He needs some help.
He needs a vote. He needs a motion to dismiss.
Ready?
He needs help. We'll help him. Whoa!
Oh, wow.
She just threw
wow.
water at me. Wow, sorry.
And now here comes the violence from the city of
Yeah, she just soaked this guy.
Hey, Debbie, thanks for soaking me. That's assault, by the way.
not even dealing with these jackasses.
That's assault, by the way. You can press charges on them. Dumbasses, dude.
Thank you, sir.
Dude, don't even record me, bro. Don't.
Oh,
Yeah.
sir, if you don't want to be recorded, go home. This is public. This is public, sir.
Don't serve me, bro.
Okay, this is public place.
You'll get your public ass whooped right now.
Hey, this is a public place, sir. You do it.
Hey, that's an assault right there.
This guy assaulted me.
Yes.
This guy assaulted me. He just assaulted me. Now he assaulted them.
You know what? You know why I'm pissed off? It's because you jackass.
You're arresting the wrong guy.
Hey,
Arresting the wrong guy.
he's not the one.
Get him out. I'm the contractor, Sally, homie.
Hey, I got it on film. That guy assaulted him and assaulted me. So we. No.
Turn around for me.
No, we didn't do nothing, sir.
It's okay. I
We
still
didn't do
have the
nothing.
authority to place you under
No,
arrest.
we didn't do nothing. Sir, no. We didn't do anything. We didn't do nothing. We didn't do nothing, sir. We were standing there. We got attacked.
Sir,
Here.
right now, it's just like
You think the prosecutors could add being such a Karen it's harming the social well-being of others onto the charges?
So you did get my text messages, and it said you didn't. Nice trick. It's just not-
Yes, Mr. Jones.
Oh.
Indeed. You didn't give this text message to me. You don't know where this came from. Do you know where I got this?
No.
Mr. Jones, did you know that 12 days ago, your attorneys messed up and sent me an entire digital copy of your entire cell phone with every text message you've sent for the past 2 years, and when informed, did not take any steps to identify it as privileged or protect it in any way. And as of 2 days ago, it fell free and clear into my possession. And that is how I know you lied to me when you said you didn't have text messages about Sandy Hook. Did you know that?
I told you the truth. This is your Perry Mason moment. I gave them my phone, and then
Mr. Jones, you need to answer the question.
No,
Did you know this happened?
No, I didn't know this happened. But I mean, I told you I gave them the phone over.
Just
And you
answer the
said,
question.
you said in your deposition, you searched your phone. You said you pulled down the text, did the search function for Sandy Hook. That's what you said, Mr. Jones, correct?
And I had several different phones with this number, but I did, yeah. Well, of course. I mean, that's why you got it.
No, Mr. Jones, that's not what happened.
My lawyer sent it to you, but I'm hiding it. Okay.
Mr. Jones,
Mr. Jones,
please just answer questions. There's no question. Mr. Bankston also only asks questions.
Sure. Mr. Jones, in discovery, you were asked, do you have Sandy Hook text messages on your phone? And you said no, correct? You said that under oath, Mr. Jones, didn't you?
I mean, if I was mistaken, I was mistaken, but you got the messages right there.
You know what perjury is, right? I just want to make sure you know before we go any further. You know what it is.
Yes, I do. I mean, I'm not a tech guy. I told you I gave in my testimony the phone to the lawyers before or whatever, and so you got my phone, but we didn't give it to you.
No, Mr. Jones. One more time. And please remember, if you need to assert the Fifth Amendment, you can. I need to know that you can do that. But you testified.
Your Honor, you don't understand. These guys just had to freak out in court. It's hard being a Karen. We need to sympathize.
So, under common law, mate, I have every right.
So you're not allowed to make recordings in the court?
Yes, I can, mate.
You're not allowed under law.
I am.
So
I do not follow your laws.
So
I have every right, mate. Under common law, I have every right. No, I have every right, mate. Under common law, I have every right. No, under common law, mate, you do not have any jurisdiction over me. You do not have any jurisdiction, mate. This is going to go to Channel 7, Channel 10 and everything, mate. You do not have jurisdiction under common law. I'm a free entity. Go for it, mate. You only have 72 hours to detain me. And that's under federal jurisdiction. So go for it, mate.
Okay.
So tell me your badge number and everything, mate. I have every jurisdiction, mate. I have every jurisdiction, mate, under common law. You're violating my rights. I want you done for assault. And that lady. I want her done for assault. Under common law.
So why was this if you're arrested? You've been arrested in relation to that?
Under common law. You do not have any jurisdiction, mate.
Okay.
Under common law, you do not have any jurisdiction. You can hold me for 72 hours under federal law, mate. Because you think I'm classed as a terrorist. Under common law, mate. So go for it.
Okay.
So you're getting done for assault. She's getting done for assault. That is assault, mate. I want you done. I want you formally charged. Like every other time I've tried. Hey, mate. And you know, because you've had to deal with me plenty of times. Hey, mate. Yes, you have. Yes, you have. Don't lie. Don't bullshit, mate. Under common law, mate, you got no rights over me. Only God has rights over me.
What's your understanding of common law?
Mate,
I just want to
all your bylaws do not mean shit. All this shit is fake illusions, mate. So keep going. What do you think all the lawyers left? What do you think the judge left? Because under common law, there is no jurisdiction, mate.
Okay.
All right, go for it.
They're on their way up, and if they can just make sure this card goes with the gentleman's belongings so he can make an official...
Yeah, I've got a push bike outside that's locked up too, mate.
Okay.
And I've got a pair of keys and evidence thingy with security.
Lovely. You'll be able to tell the officers down in Watch House about that?
It's alright. Yeah, mate.
Can I grab a bench here from one of the files just for the details of who this gentleman's alleged to be?
But the name on that is not my name. I can state that right here, right now, mate. You show it to me.
No, sir, I'm saying the gentleman you're alleged to be, okay?
Because if you look on my birth certificate application form, it is not as is stated on that form there, mate. And I want a verified criminal complaint too, mate. So let's go. We can keep playing these illusion games, mate. Go for it. Because under common law, mate, what do you think police don't like being recorded?
Well, it's not about a police being recorded. The law says you can't record in a courtroom without authorisation.
Mate, this is a public place. Isn't it?
The law says you can't record in a courtroom.
It's a public place, mate. I've got every right.
I'm not going to argue the law.
I'm classed as a freeman, not a fucking slave. Hey, mate, you're a fucking slave. Hey, mate. Yeah, because you're a laughing because you know it's fucking true, mate.
You're free to make whatever legal argument you want to make in relation to the matter.
That's right, yous are illegally detaining me right now, mate. Yous have no jurisdiction, mate. Why do you think I was behind that fucking bit of wood, mate? Because you've got no jurisdiction, mate. I'm my own fucking state, mate. Fucking learn your law, cunt.
What difference does a piece of wood make to your jurisdiction?
Because we're in the Queen's boat, mate. We're in the Queen's jurisdiction.
It's a boat, it's a building.
Fuck off, idiot.
No, you're the one who said that we're in the Queen's boat. What do you mean by that?
Mate,
Okay,
how long have you been in law enforcement, mate? And you haven't been taught any of this. Why do you think they've locked the fucking courtroom, mate? Because, yeah, I'm fucking crazy. I got mental health issues. Fucking woe is me. Fucking don't stop yous every other time yous jump on my back when I got a disintegrated disc and pinched nerve and all that shit. Yeah, legally detain me.
Hello.
Hey.
Yeah, mate, just letting you know everything's being recorded under common law, mate.
Nice.
But that's my entity, that's not me. That's a fake entity, not... No, I got every right, mate. Under common law, mate. Under common law, I got every right.
He's placed under arrest in relation to what the magistrate's issued, so...
I'm not owned by the Queen, mate.
Right, so...
Anyway, so there's the warrant.
That's right. Why use right? I want her and him done for assault. Then don't forget, I want yous two done for assault because yous physically harassed me in the court.
Mate, the understanding is you're going to have to come with us up to the watch house, alright? So I'm just going to tell you right now.
Is that of my...
No, can you just listen to me, please? Alright? I understand you're filming and that's fine. I just want you to be aware that...
What's your police identification number and all that, mate?
My registered number is 9019. I'm Acting Sergeant Lachlan Ibbott. I need you to come with us. I don't want to have to use force, alright? I need you to come with us up to the watch house. If you don't come with us voluntarily, alright, we will have to use force.
So am I under arrest?
Yes, you are under arrest. Do you understand?
So under common law, I am under arrest.
What I'm saying? You need to
no, I do not understand. I do not understand and comply.
One more chance. You're going to come, or are we going to use force on you?
I'm more than willing to go, mate.
Well, let's go then.
Yeah, well, I'm recording the whole thing while we're going.
That's right.
Mate, I got every right. I got every right to record. I got every right to record under common law. Under common law, mate. I got every...
You know the situation's bad when Karens have day jobs as lawyers, judges, and police officers. It's like they're White Walkers.
Why do my son hairs with
video
if
from
you
the
don't
phone
stop
or from the
yelling,
camera.
this is going to be a problem for you.
Three of them
I don't
pushed
care. Okay, cool. Then get over here. You're not going to arrest me. I sure am.
She's good. She's good. She's good.
We are not doing this right now. We are not doing this.
No,
it's okay.
Dude, keep your hands off. You better not my fucking wife. Dude, she's going to cuffs. She's going to cuffs. Listen, my daughter and my son-in-law are both local police officers.
I know. And you
I'm calling right now. Dude,
you would not want them putting your hand. Somebody putting their hand. You are not going to fight a cop.
hey, you arrest my fucking wife, you're going to be sorry.
Let him.
My son and my daughter are both police officers.
I don't care.
Oh my God, are you fucking kidding me, dude?
I'm so done listening to you scream. Why? Because it's the truth. It's No, because I want to hear everybody talk.
15 years of
I want
bullshit.
everybody's story.
You're hearing them first. You don't understand. Ask any neighbor.
That doesn't mean I'm not going to listen to you.
You need to get the. If you don't get the cops there for right now, you're gonna have a problem. We're not doing that. We're not threatening that. You need to get the cops off her. She's gonna sit in the back of the car right now. That's what we're gonna do. That's what we're gonna do for right now. He needs to get the cops off her. We're not gonna do that by your demand. She's gonna sit in the back of the car. She's gonna be in cuffs.
Okay,
that's what's gonna happen for right now.
From the top.
Let us work. Let us just work this through.
Don't do the crime if you can't do the time, please. Especially if the crime is being a Karen.
I'm in the Seminole County Circuit Court in Sanford, Florida. It's 6:30 p.m. and a long one-day trial has come to an end.
The jury finds him guilty of driving under the influence.
That defendant is 46-year-old Lisette Gonzalez. Although a verdict for Gonzalez's DUI charge has already been reached, her attorney makes a final plea to Judge Fred Schott.
Your Honor, not enough evidence presented for the jury to find the verdict that they did. They didn't do all the field sobriety examinations that should have been done.
During the trial, it was revealed that Gonzalez was never given a breathalyzer or had her blood drawn. Yet arresting officer Michael Wagner recorded that she tested above the legal limit of .08 in his official report. Wagner claimed it was an honest mistake, but observed what he believed to be intoxication.
I respectfully ask that this court grant the judgment notwithstanding the grounds.
The attorney is asking the judge to use his power to overturn the jury's verdict and acquit the defendant. It's a move rarely seen in the courtroom.
Right. This isn't a purely circumstantial case. And so I'm going to deny the motion for JOA.
It looks like the case is closed, but Judge Schott has other business with Gonzalez.
Now, we have this other case for driving while license suspended.
2 months after her DUI arrest, Gonzalez was ticketed for driving with a suspended license. Problem is, the only reason her license was suspended was because of the inaccurate paperwork filed by Officer Wagner.
I want to be enlightened.
It was a mistake, admittedly, by Michael Wagner.
I know.
He testified to that today.
He caused her to have her driver's license suspended for at least a few months for nothing. So you're going to know across that case? I'm not going to get mad at you today.
The judge is addressing prosecutor Diana Mears.
Perhaps you can get back to Your Honor, but at this point...
Wait a minute. Did you hear the uncontroverted testimony of this officer?
Your Honor.
Then I want you taking him up on perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor, and that is not true.
I'm dismissing. I am dismissing this charge. No, I'm dismissing the charge.
The judge has just dismissed the defendant's upcoming case, but he's not done yet.
This whole case was fishy, and I have no idea how to... You know what? You know what? I'm granting... I'm resuming the sentence. I'm granting the JOA.
Judge Schott has just reversed his decision and acquitted the defendant on the spot.
So you're granting it because you don't agree with the state's decision?
I'm granting the JOA in fairness.
In fairness, because you don't like the state's decision today, Your Honor, on the case?
No, you're not. Now that I consider what Officer Wagner testified to and how many times he basically tripped over himself just to arrest this lady with no real probable cause. You're done. Motion to JOA is granted.
And you're not going to provide a written order on that?
No. Want to appeal me? Appeal me.
Thank you, Your Honor.
Case should have never been done. Never.
Thank you for letting us know that, Your Honor.
The defendant, Lisette Gonzalez, walks out of the courtroom free of all charges.
The law teaches you how to live respectably in society. Karen bylaws tell us it's not that serious.
She was put on notice that there was going to be...
Even you don't testify to that.
An
the
application.
best you have testified to about notice is I do believe there was talks about application.
Exactly.
But I'm reading your words, right?
Exactly.
But I don't recall telling her specifically how the process
Exactly.
works.
She was on
that
notice.
Is not
There's an
putting her on
application.
notice, Mr. Paulino. She's going to have to fill out a 10-page thing that asks her
That's not.
to list.
She can't go down to the condo place and get an application.
It's not.
This is standard practice, Your Honor.
Okay, Mr. Paulino, you're dead wrong.
That's your opinion.
No, that's my ruling, pal. And let me tell you something, Mr. University of Miami Law School. I taught at UM for many, many years, and you right now are embarrassing us. You do not show that kind of disrespect, okay? If you don't like what the judge is doing, then you take it to the next forum. But you do not sit here and say that's your opinion like a baby when a judge rules against. Don't even utter another word. You got a lot to learn about what it means to be a litigator and a lawyer. I don't want to be either. Good, because you don't have it in you. But you got a lot to learn about what it means to be a member of the Florida Bar. And if you think that this kind of petulance and babiness on your part to turn around and tell a judge who you disagree with, well, that's your opinion, is going to get you anywhere, you are sorely mistaken. If there's nothing you should have learned in the last 2 years as a law student, there's something you should have learned as a human growing up, that you do not show that kind of disrespect. You don't like it, take it to the hallway. But you do not look a judge in the face, because I don't care what you think about me. You got to respect this process. And if there's anybody who I expect to respect this process, it's a second-year law student at the University of Miami. Verdict for the plaintiff, $450 and court costs.
Citizens of the world, beware. Karens aren't the type to listen to the law or authority figures. They just listen to the Council of Karens.
All right, appearances for the People versus Frank Mishaw Jr.
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
No, it's not for you how it works.
Yeah,
you're on Friday.
Are you up? Please sit at the desk representing yourself.
The judge needs to address you, sir. Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
no, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
Maybe I'm not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to?
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
And if I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has,
he can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on a record?
Yes.
Are you on your oath to the Constitution?
Hold on, are you picking him up? That's one of the reasons I want you up here, is there's a microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oath to the Constitution.
You haven't.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
May
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record.
Okay.
So with that being said.
Well, hold on. You can stick around if you want to, but I'm not gonna obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So today,
You have a jurisdictional argument you want to make?
what I've served notice.
Sir,
on
it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a.
Yes
multiple
or
arguments.
no?
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your
Okay,
jurisdictional
so-
argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that?
I work
criminal
under the authority
or-
of the state of Michigan.
What is it, under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law, so I'll need to know.
This is not admiralty.
What is
And
it?
it's not common law.
Which
It's
one is-
statutory.
Okay, so it's statutory, that is what, civil?
No.
So what is it? For the
My
record, I need to
jurisdiction is
have-
both civil-
I can't defend myself unless I have it on the record. Is it?
My jurisdiction.
It's only two.
Sure, shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is?
This is a criminal case.
Okay, right, so is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record?
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the
A
people of the
corpus
state of
electi.
Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
You want to see it?
affidavit, sworn affidavit?
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party, who have I injured for the record?
The state of Michigan
How can I
are
injure
bringing the
state?
charges.
How can I injure the state?
Sir, sit down. Sit
I prefer to stand.
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat, wow.
You're probably going to hear more than one.
I see.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, would request a mutual order of sequestration with an exception for the
So-
OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name.
your witness, yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name?
No, you still will.
That's fine. Thank you. Witness.
Your Honor, the people called Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is, okay, so right here.
This is the probable cause hearing.
It says.
All right, stop. Right now, the question on the table is, you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied? Not
because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objections to the evidence.
That we are having a preliminary exam when I haven't had a probable cause hearing that I did not.
They're the same thing, Mr. Michaud.
It's still on this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different date that says a preliminary.
Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two separate?
Have you ever had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we did.
I understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that?
At what point did I waive it? If it's a hearing,
you didn't waive it. There's nothing to hold.
Do I have a right to have a probable cause conference?
No.
What?
You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause conference. It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hall and have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony. where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to—
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that, you know, the waiver does not preclude him from
not at all
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to their burden, he also maintains the right to, you know, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to—
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
criminal what?
Bid bond.
Hold on.
I requested the bid bond, the performance bond. I have an affidavit.
There is no bond.
There are bonds. This is
okay, listen. You can't tell me something and then just disagree with me and think. Listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe. Okay, that's just the way it works. My courtroom, I get to decide how it's run. There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone here has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address. Okay, so
I'm not addressing any of that crap you got in front of you.
Well, since you say you don't have a bond, can you express that in a via affidavit so I can have a—
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent a affidavit of fee schedule for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice, and
great. Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice. Okay. Also, I served you notice on my power of attorney.
Okay, you said that.
Right, and
move on.
You haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't recognize any of that.
United States citizen. I am
stop.
actually
Hold on. Stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent, or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you and nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does mean, hold on. It does, it should mean something because.
Prove it, please prove it.
Can I prove what?
Prove that I am not that I am the artificial person.
I can prove you're Frank Michaud.
I have full faith and credit.
I can prove.
Okay, so
hold on. You've asked me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And
you proved it for me.
You threatened me.
But if you're not you, the threat means nothing.
It doesn't mean nothing.
Okay.
But you still threatening me, and you're using it under color of law.
Okay, listen.
And plus,
listen to me, Mr. Michaud.
You have.
I've wasted too much time with you. Yes or no?
So,
sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
It's finally happening. Being a Karen has been placed in the law book as a punishable offense.
Yeah, it's time for him to go. And I don't know who he is, but whoever can sit here at a tragic moment like this and laugh and smile when somebody has lost a family member. I mean, the entire time that Mr. Zerker's sister was speaking, that clown, and that's what I'm going to call him, a clown, was sitting there smiling and laughing. Yeah, you can go too, because if you don't know how to act, you can go to jail. So leave. Anybody that can sit there and laugh and smirk when somebody, take her, she's going in the back. She's going in the back. Anybody else want to go? You can go too. This is a court of law. And these are very serious matters. And I understand you all are upset because your loved one is going to prison. But guess what? She's going to prison for the choices that she made. These people are here grieving, saddened, because a senseless act took away their loved one. And you all are sitting around here like it's a joke. Not in courtroom 502. Not today and not any other day. Ma'am, you are being taken into custody for criminal contempt. Your disruptive and disrespectful behavior disrupted today's proceedings, and you, ma'am, are going to the Wayne County Jail for 93 days for direct criminal contempt. Anybody else want to go? Try it. Try it. Oh, my mouth? Well, thank you. Your mouth got you 93 days.